Be seated, thank you. Mr. Granger.
May it please the court, counsel, ladies and gentlemen of the jury, I'm now going to make a final argument summation on behalf of my client, Kayle Fleischauer. In this final argument, I'm going to discuss the evidence, the believable evidence in the law and the Constitution of the United States of America. My hope is that when I present this argument or summation, it'll help you in your role now as a judge of the facts, judges of the facts. It's your duty without favor, bias, prejudice to judge the facts in this case in the believable evidence and then determine if that believable evidence proves beyond a reasonable doubt that my client shot his only son. That's the issue. It's not any fight. It's not any wrestling match. It's not any pre-existing fractures. None of that has anything to do with the causation of this case. And the causation is a shooting of Chase Fleichauer in the forehead, 3 to 6 inches away. So I'm not going to spend a whole lot of time like the state did on all these injuries and that, but I am going to go over the evidence of innocence as far as my client not shooting his son. Now, what's really interesting here is the state's argument. They're arguing what we've presented. They're worried about the DNA, they're worried about the GSR. And what they start off their argument with is this law that the judge gave you. If you can reconcile the evidence upon any reasonable hypotheses, and that's hypothesis is a fancy word for explanation. If you can reconcile the evidence upon any reasonable explanation consistent with Kayle Fleischauer's innocence, you should do so and find him not guilty, a verdict of not guilty. And the reasonable explanation that we're going to present to you is that Chase Fleichauer accidentally shot himself in the head. We're going to establish that. We're going to prove it through the circumstantial evidence. But before we get there, you know that when you walk through that back door in a criminal court case, criminal jury trial, it's entirely different than everyday life. Everyday life, you read in a newspaper, oh, they caught the guy, he's guilty. In this courtroom, you must presume the opposite. You presume that my client is innocent. You presume that he did not shoot his son. And that presumption is one of the strongest in the law. And before the state can prove its case, they have to prove beyond a reasonable doubt each and every element of the crime. And in this case, the main element is first element, causing the death, shooting him. Why do we have those laws? Well, you've seen here a classic example of why when a citizen in our country is charged with a serious crime like this, why he has a presumption of innocence and proof beyond reasonable doubt. This is an adversary proceeding, ladies and gentlemen. Don't doubt it. The state wants to win, and the defense wants to win. And the power of the state, how many law enforcement officers in this case, how many experts, all that power and money is against one guy, Kayle Fleischauer, to convict. That's what they want to do. That's what the 4 deputies want to do. They're here to convict and to balance the scales of justice. Our forefathers decided, well, we're going to presume the person innocent that's charged, and before that person can be convicted, the state must prove, our government must prove, beyond a reasonable doubt that the individual committed it. Beyond a reasonable doubt is a term that the judge read to you. But here's the real definition of it. It's in the instructions. I know you'll get them it's important, it means such a doubt as would cause a person of ordinary prudence, a reasonable person, to pause or hesitate when called upon to act in the most important affairs of your life. And make no mistake about it, this is an important affair of your life, of my client, and the state. You've seen the state operate in this case. A most important affair of your life. So that when you look in the mirror 10 years ago, 10 years from now, and you think back at this case, I made the right decision. I'm comfortable with my decision. Proof beyond a reasonable doubt. If you hesitate, if you pause about the proof in this case, you must find him not guilty. Such doubt it was cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of his life. So, a couple of other things. The pictures, many times you've seen the same pictures, and they're hard to look at. The autopsy pictures, the pictures of Chase Fleichauer lying there. And you might wonder why we see those pictures all the time. Well, they may well be relying on bias, prejudice. You look at the pictures, oh my gosh, he's guilty. Don't do that. You're the judges of the facts. You have to look at those pictures and decide the evidence in this case. You cannot shy away from that. So remember that. You're objective. There's no bias or prejudice. And now let's, after those rules that I just cited, let's look at this case. Let's look at it. My client got married when he was young, had two children, 3 and 5, boy and an older girl, younger boy. And after the divorce, as Summer Fleischauer said, we went over there 2 days a week. We visited our dad. He was a hands-on dad. He wasn't some kind of not seeing his children. He had to put a tattoo on his arm about his children. They would visit every 2 days. When they got older, it was different, but when they were being raised, he was their dad. So, and you see that he had insured his daughter, Summer. We know that. He loved his children. She said she loved them. I'm not going to go over the text, but you heard them. The texts were, she loves her father. He loves her. He loves Chase. He took him to Brainerd to start college. You saw the photo. I'm not going to get these photos out. And Summer took that photo. He's up there with his son with his arms around him, with the same shirt on. You're killing me, Smalls. What does it? Right below it, it says Sandlot, which is a movie. It's a shirt from a movie. But he's up there with him, taking care of his son. And they visited him. There's calls, 28, I believe the evidence was, in a month and a half between him and his daughter. So he's not a father that you wouldn't respect. He was a good father. And as far as the text messages, all of them I went over with the I love you, but also as far as the alcohol. He asked his daughter, well, what should I get Chase for? Either it was Christmas, birthday, or something. And she said alcohol. Alcohol and a t-shirt in the text messages. He asked again later, or earlier. He said, what should I get for this deal? And she said alcohol or money. Yes, she might be kidding. Obviously she is. Maybe not. But she's entered that into the picture again. So What else does he have here? Corey Burton said that he was present when the children helped him, Kayle Fleischauer, move into his new home in New Richmond. They had a relationship with their father, ladies and gentlemen. Summer Fleischauer told Detective Mikla, Kayle Fleischauer really loved his son. He loved both of us, but he loved his son more. He bought him a Jeep to rebuild that summer. And then he calls him up, and they're going to have a celebration of life for his father that would died a month before approximately. And they were going to come out to his house on Friday, the 13th of April, 2018. But you might remember that what he said to them, he said, well, if the weather's bad, you don't need to come. He wasn't telling them to come out there as Sommer portrayed. He said that. And Sommer, in her testimony, Dr. Dunn said, first there's a denial when you lose somebody that you love in bereavement. First there's a denial. Then she says there's anger. And you saw the anger in Sommer. She isn't over the death of her brother. And it might be next year, it might be a long time from now. But there's that anger there. And she tells you that my client loved his son and he loved me. I wasn't as close to him, but he loved both of us. There's a picture of the football. There's a picture. I'm not going to, it's in this here. There's a picture of him, my client, at a football game with his arm around his son just after or before the game. That shows that he was going to the football games. These folks that say, well, he never went to a game, he went to a game. He was her father. He's sitting here being charged with killing his only son that he loved. Remember that. And these people that say, well, he didn't do this, he did that. These children helped him move. What does Corey Burton say? He talked about his children, my client. Corey Burton, who was a friend of his. So before we get into the evidence, you keep in mind what kind of father he was. He was not a non-father to these children. He was involved in their life. Proof by the telephone calls and proof by the text messages. And the friend, he had a hard time, his friend for years, he had a hard time admitting it. But I asked him, well, had you ever drank alcohol with Chase Fleichauer? Yeah, well, did you go to parties in college? Yes. Did you drink? Yes. You go to Florida for spring break in 2018? Yeah, I went with Chase. And did you drink there? Yes. So it's not anything new, and we all know that. Drinking alcohol by college kids. So that's my client. My client, who also worked, according to Corey, worked at U.S. Bank as an IT guy, and he worked there before at 3M, and that's where Corey Burton met him. So that's his background. On the 13th of April in 2018, he had this telephone conversation with his daughter where he told her, if you can't come, you can't come. No, we're coming. Chase is coming up. So they go in her panel truck or panel car, and they drive to my client's home, Kayle's home. And what happens there? They come in, back up. What did Sommer Fleischauer say when my client said, well, what do you want to drink? She said, and it's in the text, she said vodka. That's what she said. So, and what do you want to eat? Chicken. So he was making chicken for his children, and he was getting a bottle of vodka for his daughter, who's 21. And that's what he did. They arrive at the house. He's got the chicken going, he's got the vodka, and he's got beer for himself and his son, who's 19 and a half. They have a conversation while they're eating dinner about various things. One of the things was that my client said, I have a gun on top of the refrigerator. And you might remember the testimony of Kayle Fleischauer. She said in her testimony here, well, he might have been kidding. Well, in her statements prior to this, twice, 414 and 416, when she was interviewed by Detective Mikla, she said, no, he was serious. He meant it when he said he had a gun up there because he lived in New Richmond on the outskirts, and there were home invaders. He wanted protection. And it's not unusual if you have a gun up there and somebody breaks into your house and you're not in your bedroom, as the state might want you to think. He also had a pistol in his nightstand, as you remember. So he tells them that at the dinner. He tells them about apparently Summer had some issues with somebody. He tells his son, you should protect your daughter, you should take care of her, and he said, don't be a pussy. And they're arguing, talking back and forth. You've got the text messages between him and his girlfriend. And in those text messages, there's LOLs, having fun, getting drunk with the kids. There's no fight at that dinner. And if you need more proof, find it here. Excuse me, I'm sorry. I should have had this organized and I didn't. We're going to take these and give them to my assistant lawyer. Could you find that photo? Okay, so we'll get back to the dinner table. They took selfies during the dinner, and at 1:18 a.m. in the morning, and this totally proves that there was no argument or fight when Kayle Fleischauer went to dinner. Find it. Oh. Oh, yeah. Yes, I found it. Pardon me. I always had a hard time keeping track of documents. But here's the document. Here's the 1:18 in the morning. You've seen this. It's in evidence. It shows all three of them. Summer took the selfie at 1:18. So was there animosity? No. The state says, well, before that, they were fighting. No, they weren't. Here, that's what you have. So now, she goes, and here's another photo of my client with his son at a football. He's got the football uniform on. That's in evidence. That shows that at least he was at one game. So now, at the end of the dinner, they continue to drink. And Summer is drinking vodka, and she's mixing herself. The guys are drinking beer, and she said that once the beer was over, that her brother was sipping vodka. Well, then she went to bed. She thought for a day or two that she went to bed at 10:30. Then she realized that her text messages on her phone are approximately 1:30. So she didn't know what time she went to bed. She was drunk. And one other thing, she said on that stand under oath that she wasn't drunk when she saw her brother the first time. She said she was very drunk and drunk and drunk on 3 prior times. But on the stand, she chose to say she wasn't drunk that morning when she found her brother. Think about that. You have to judge these witnesses and decide what they're telling is the truth or false. And that's your job in the credibility instructions in the instructions. So she goes downstairs, and there's no evidence in this case that she heard noise all the time down there. She heard, I would never hit my father, but it wasn't continuous noise. She was asleep. He's saying, well, she heard noise all, no, check your notes. That's not what happened. That just isn't true. But what she did, she called for her brother to come down once, and he didn't come down. She said her brother and father talk loud when they're drunk. But she never said she heard a bunch of scuffling and fighting. She never testified to that. So we now have the noise at about 4 in the morning, a little after 4. What she says is she heard the noise, it sounded like a chair falling over, which is proof that Chase was sitting on a stool. It sounded like that. She got up and went quickly up the steps, and you've seen the pictures, it's just up and up. And there, lying there, is her brother. Now, she sees her brother, and when she looks up, she sees her father walking down the hall. And he was coming from his bedroom in that hallway, and he's walking down it, and as the state proved quite convincingly, he was really drunk. I think they had up there a 4 something, if you take it all. But he was totally drunk, and he had just, obviously, you look at his bed, there's a picture of his bedroom. You can see the pillow at an angle where he would have went in his bedroom and laid on that pillow, being so drunk. And as far as what these two guys, the father and son, did before that, was it a wrestling match? Was it a fist fight? You decide. It was an altercation, and it appeared to be that they were wrestling, tossing each other around. My client, the father, the son wants to prove to him that he can take him, and it went on for a period of time. But those injuries that Chase Fleischauer received, they called Dr. Treadle. He went and looked at the autopsy. Most of the injuries are not that serious. They're minor bruises, which you would receive when you're under the influence of alcohol and you're wrestling with your father on a hard ground. And to say he had no injuries, he didn't have as many injuries, but he had a scratch on his elbow and a bruise on his back. You saw the picture of the bruise. So that now, my client gets to the scene, and he's trying to calm Sommer down. She wants to call 911, and what she said, she didn't say it here under oath, but what she said back then on 2 statements, 2014 or 414 and 416, she said, I think my dad was too drunk to get in his phone. He was flustered, and obviously he was too drunk because of his blood alcohol count. But she went down and got her phone, 911. He doesn't know what he's doing. They finally get into the 911 call. And what Sommer says is, I get the 911 tape transcript. In the 911 call, apologize for not having these set. In the 911 call, she says, I think that my brother's been shot in the head. That's what she said. And then the dispatch says, you think your brother's shot himself in the head? And Do you remember the 911 person? He said he repeats that to make sure that what he heard from her was correct, because he's sending police officers out to the scene. He wants to know if it's somebody got shot or if it's a self-inflicted gunshot wound. Obviously, he wants to know that. That's common sense. And what did she say? She did not correct him. You think your brother shot himself in the head? There's no correction on that. So he calls out self-inflicted gunshot wound. And then later, when they're on the phone, she's trying to revive her brother. My client, as you saw the pillows, she admitted she told him to get pillows, and he did. He was trying to help his son out. Kayle says, hey, we're at 14 and we need help. That's what Kayle said. He says, 1489 142nd Street, my son is gone. We need help. My son is gone. Later in the 911 call, you can hear him crying in the background. At the end, he says, oh, my son, God damn it. God damn it. And you hear crying. Now, Sommer's trying to revive her brother. Kayle is up there with the pillows, or the towels, and the doorbell, or not the doorbell, Sather, who was the first one there, and he's thinking this is a self-inflicted gunshot wound. He knocks on the door. And who comes to the door? My client walks down and opens the door for him. And it's undisputed. But what does Sommer say? To this day, she testified in this courtroom that she opened the door. Is that still the grief and the anger that she has for her brother, that she believes that she opened the door for Sather? But my client opened the door, and there were dogs barking. And you could hear on this 911 call the dogs barking. He has 2 dogs. And what did Sather say? Put the dogs away. What did my client do? He put the dogs away. He put them in the back bedroom to the right, although there's a dispute there. It might be to the left if Mikla is correct. But he put them away. And they were put away until later that morning, I believe. In any event, he walked up and down that hall. When he came down the hall the first time, he walked back to get his dogs there, and he walked back to where his son was at. 3 times. If he had shot this guy, this son of his, if he had shot him, if he was that devious a man to shoot his only son, would he leave the firearm right there in the hallway for the police to find? Think about that. How unreasonable is that argument that the state makes? If the gun's there. So he's going back and forth. Sather wants to know where the gun is. He's looking around. The second time around, he says he saw the gun in the hallway. And by the way, you saw the gun, it's a black gun, and it's a dark hallway. How far could he look when he said he was in the kitchen? How far down there could he look in a dark hallway with a dark gun to see that firearm? 10 feet, 9 inches? That's unreasonable. Maybe 5 feet, but 10 feet, 9 inches right on this side of the bathroom? Think about that. And when he went to get the gun, he was not investigating a crime. He was safeguarding the scene of this self-inflicted gunshot wound. He picks it up. He doesn't measure anything, doesn't take a picture of it. Why? Because it wasn't being investigated as a homicide. And he puts it up on top of the bathroom, of the refrigerator. He goes back out, and now the ETs are coming. And by the way, back up, Sather says that my client was hugging his son at one point in time when he arrived. When the ETs came, one of the ETs said my client was on top of his son, hugging him. So the ETs come, and Coleman comes right behind him. Coleman's right behind him, and he goes up to Sather, and Sather says he found a gun, it's on the refrigerator, and he takes the gun down. Coleman, who's got more diplomas, and he's done this and that, he's an accident reconstructionist, he's this. Coleman, just instead of leaving it up on top of the refrigerator, he leaves it on the counter and takes it apart. 30 seconds to do that, and I asked him, well, how much time would it take to put it back together? 10 seconds. Think about that. How safe is a gun that can be put back together in 10 seconds on a counter where neither one of these officers know if anybody else is in the house? Instead, he takes it apart and he walks down by the above on the steps, and he yells down to my client. But let's back up a little bit here. Before they dismantled the gun, they took my client, who was near the body, they had him go down to the landing, and he cooperated. He says, right, I'll go. And Sommer, she's furious. They had to forcefully carry her down to the lower level. But my client, he cooperated. He took the dogs where they went. He's doing the pillow or the towels for his client, for his son, and he's not doing anything disruptive, really. Now, they want him to go down to the entryway. Well, down there, he's rubbing his belly and saying he's fat and laughing. You've heard Dr. Dunn, the counterintuitive conduct of people who are facing his only son with the injury that he had. But that's all he's doing at that time. Now Coleman, the detective, Coleman, he's at that landing. He says, starts questioning him. And what does he say? I did not kill my Chase. I didn't kill my Chase. What happened here tonight? I have no idea. Why would they question him like that? Well, Coleman says, well, he had blood all over him. I asked Coleman, I says, well, didn't you know that he had hugged his son? No, I didn't see that. Well, didn't the ET or Sather tell you that he was hugging his son and Sather had his arm around? They never told you that? No, I didn't know that. When I saw the blood, I had no idea about that. Do you believe that? Can you believe that? As jurors' findings, whether or not somebody's telling the truth? That is so absurd, so outrageous to say that he didn't know that blood was from hugging his deceased son. But that's where it started. Kayle is not sober. He's cooperating as much as he can, and he's got a high blood alcohol count. But when he's asked that, and they start questioning him what happened here, and he says he has no idea, I didn't kill my Chase. And then Coleman says, well, you have a lot of blood and stuff on you. Is it all right if we take some pictures here real quick? And my client says, no. Well, he said, no. Did they say, okay, we won't take them? No, they took the pictures. And what he did was ridiculous. And yet, when you think about it, would a person do that if they shot their son? Would a person cause that kind of dislike, I suppose, by the officers, by exposing himself? Although Duran, who didn't handcuff my client, Duran said he wasn't offended. But they make a big deal about this right now. And when you think about it, if he actually killed his son, he wouldn't do that. He wouldn't want to irritate the cops. And the idea that he told his daughter not to talk to the police, well, think about that again. There's two sides of that coin. Because he didn't know what happened. He didn't know, and he sees his daughter there. He doesn't know if his daughter was involved. He doesn't know what happened. What good father? He said, well, don't talk to the police. Up here, he's thinking, I didn't do it. Well, maybe she did, and I don't want my daughter, my only daughter, to get in trouble. Isn't that another reasonable conclusion from saying don't talk to the police? Why would he be concerned about her talking to police unless he thought, well, maybe there's something there that she did? So when he says, oh, Kayle Fleischauer told his daughter not to talk to them, well, you figure that out. And then Kayle says, when he's getting handcuffed, I didn't do anything wrong. And then Coleman says, on the stand, the veteran law enforcement officer. I said, well, why did you handcuff him? Well, he was being aggressive. He was tightening up. And I said, well, what do you mean by that? And Coleman says, he had his arms out like that and was coming towards us. And I said, look, Sergeant Coleman, he had his arms out like that? Have you ever seen somebody coming at you like that before? Hundreds of times. Rely on your own life experiences. Rely on the movies you've seen, on the shows you've seen. Whenever there's a confrontation between somebody and the police, does the guy go, I'm going after you like that? No, not at all. That's absurd. That's unreasonable testimony. But that's what he said. And then they grab his arms, and he didn't resist. They handcuff him, put him in the car for 9 hours. Now they go upstairs, and now we have the paper. The paper that was put where the gun was supposed to be. Before that, at some point in time, Durand and Coleman and Sather took some photos that you heard about. They never took a photo of that piece of paper when it was originally put down. But when Coleman and Sather are at the counter where the gun is at, they have a conversation. Apparently, you don't hear it on the audio at all. A little bit of it. You say, put it here, put it there. There's no report. Neither one of these experienced police officers made out a report about placing a piece of paper where Sather found a gun. Now, I don't get a real charge out of questioning police officers' investigation, but you have to look at it as objective finders of fact. And what are they doing? They take a piece of paper, Coleman draws a picture of a gun on it, and they set it loose on the floor. And Sather, to this day, said it was an approximation. But in any event, that paper was there, and the next chapter of the paper was that when Stalkey came with his crew, they didn't touch the paper, they didn't want anything to do with it because it's an approximation. With respect to the spent shell casing on the entryway, they didn't want anything to do with that because that was an approximation. They were dealing in scientific, where was it? They're investigating what may be, to them at least, a crime scene. And there was no measurement at that time of where that paper was. And I apologize, I'm going to try and get this done as quick as possible. You have to understand that this is extremely serious. I know some of you are probably having a hard time following. If you are, I'll do my best, but it's extremely important. So the piece of paper, on the 16th, Brandy Hart sees it there, puts it in her file, doesn't do anything with it until May 1. And May 1, she finally logs it in. So Coleman gets a hold of his boss, and his boss sends out DeMuling and Mikla to be the investigators of this case. So they come out, they look at the scene, they seal it up so nobody can get in it, and you see the pictures that Durand took. One of the pictures has a towel on the floor in the bathroom. When the state crime lab got there, there was no towel on the floor, and the toilet seat was either up or down. So the crime scene wasn't sealed that well. In any event, the crime scene is sealed. Mikla and DeMuling, 50 years, 45 years of experience investigating cases, they decide in their conversation, we're going to get a search warrant for Kayle Fleischauer. We want to search it to get his DNA a sample of that, and a sample of his GSR. And in that warrant, believe it or not, I went through it, what Demuling says is that GSR is commonly found on people that have fired a firearm. Well, apparently it isn't if there isn't any GSR, if the results come out as they do, because there was no GSR found on my client. But the other, when they got a search warrant for the DNA, Demuling says in the search warrant, the DNA would show that he held the gun. No DNA. And if you want more than that, when Fleischauer, on a consensual search, not a search warrant, she allowed them, and Mikla testified about this, she allowed them to take a swab of her GSR for GSR and DNA. And when asked, actually it was direct testimony, it wasn't cross. Why he did that? He said to rule her out as a suspect. Well, that man over there, he had the same results as Fleischauer. He wasn't ruled out as a suspect. Makes you wonder. In any event, you then saw his, at 1:30, about in the afternoon, you saw him, and he was cooperating, sat in a chair. They took the swabs, whatever they did, the nurse did. And then he was, and you see in the video, he was putting on his orange jumpsuit. And what you do see also is that he cooperated. He had a 1.9 at that time, according to the alcohol, and he cooperated. So he goes off to jail, and the state comes, because their thing with Stalky, he's going through the house with a video camera first to see where everything is, and then there are pictures taken before anything is touched. And you'll see a picture, Exhibit 319, ladies and gentlemen, that we showed you. In this picture, you'll see on the nightstand of Kayle Fleischauer, it's either a blue something, fabric, or it looks like a towel, hanging over the nightstand. You see that? That's when the state came and took those photos. That would not be there if what this state, what they claim, that my client went in that nightstand, got a gun out of that holster, and went back and shot his son. That towel wouldn't be there. He would have opened it up and shut it, and the towel would either be shut in it or fall out. That's circumstantial evidence. The judges told you about it. The state's told you about it. That's circumstantial evidence that's hogwash. That he went in that room and got a gun. They have absolutely no evidence of it. In fact, this picture proves that he did not. 319. So they take that picture. They take a picture of the piece of paper on the floor, all the photos that you've seen, and one thing important, Stalky, who is the premier expert of crime scenes, he said that because of the feet in the stool, that Chase Fleischauer was on the stool when he was shot. So we've got him on the stool when he was shot. So the state leaves. The measurements were somehow measured. I didn't follow it real closely, but Tracy Dager came up with the fact that where that piece of paper was 10 feet 9 inches from the foot of Chase Fleischauer. you see that exhibit the state showed you, there's no stool in that. And if the stool was up, we're sitting up, it would be up like this, and the ejected shell would be down to the left. So it wouldn't be 10 feet 9 inches if you're sitting on that stool. And then we really don't know where that piece of paper was. But let's go back to how did Chase Fleischauer get to where he was at on that stool? What does the circumstantial evidence tell you? Because there's no direct evidence of this, but the circumstantial evidence tells you, you see a picture of his bedroom, the blanket is messed up. That would be a reasonable belief that he at some time was laying in that bed. That was messed up. Then you go around and you see his billfold on the steps and a bloody napkin. That would be circumstantial evidence that he went up and down the steps at some point in time. So then you go to the upper level and you see another bloody napkin, and by the way, it's his blood, a bloody napkin in the wastebasket that goes in. All right? So now we have a trail. He's in bed with the blankets messed up, going up. You can reasonably, now he's in the upper level. What does he do? Well, you've got photos. They didn't check for blood. It might have been too cold out for him. Who knows? But they went out, they saw that somebody barefoot walked out in the patio and came back. That's circumstantial evidence that somebody went out there, footprints in the snow. So then you have the person coming back in, and this is the most important part of this evidence. And back up. At some point in time when he came back in, or before that, he went up on top of the refrigerator where he was told the gun was at. And for the temerity of the state to say, you see this picture, you can't see the gun up there, can you? Well, you know what? In that picture, you can't see the BB gun either, and we know that was up there, don't we? So what kind of an argument is that? That's an argument by the state when they know they don't have a case. So he gets the gun up off the refrigerator. What is he doing with it? We don't know. He has his shirt off. Kayle had his shirt off. So he has the gun, and the next thing, he's in the living room. Either he came from the refrigerator with the gun, or he went out on the deck with the footprints and came back in. But in the living room, there's an unspent shell of this gun. And the expert said that that unspent shell came from that Taurus. Now think about that for a minute. Why would that shell be there? That shell would be there only if Chase Fleischauer was checking to see if it was loaded. Because my client, he put the gun up there. He knew it was loaded. But if Chase had taken that and ejected a shell, and the shell is there, and the expert says that shell was ejected from that gun, so that's evidence undisputed. He takes it and he ejects it, and his hand gets on that barrel. You've seen the barrel, it's 3.5 inches, about 3 inches, but he touches it. And then he goes over, and we know he sat on the stool. We've heard that from Stalky. We know that, and he's on the stool, he's drunk, as Dr. Arden said, he's a young 19-year-old drunk with a gun, a loaded gun. And he doesn't realize it's loaded because he had ejected a shell. So he's looking at the gun and it went off. Ladies and gentlemen, that's a reasonable explanation of what happened here, based on the circumstantial evidence. The circumstantial evidence is such, 3 to 6 inches, it went off. And what else do we have? We have his gunshot residue on his left hand and his right hand. We have DNA on the pistol, and we have a 3 to 6 inch separation between the gun and there. How do they disprove that? They don't. They talks about a reasonable hypothesis, a reasonable explanation. That is a reasonable explanation. Particularly, like Dr. Arden said, when you're sitting on a stool and you're drunk and you have a gun, and obviously he had ejected a shell, no other reason for anybody else to eject a shell. And at the same time, there's no evidence whatsoever that my client ever touched that gun that night. The state says, well, it's his gun, his only gun. Did the state forget that he inherited these guns from his father? That he just got them? So the magazine, he probably never touched it. Who knows? But does that matter? We don't know when that DNA of Chase Fleischauer was put on that barrel. But we do know it's there. And we also have been told by the expert, by Coleman, that they didn't see any blood on the gun. So we didn't test it for blood. So you take the blood DNA out of it, you take the saliva DNA out of it, you take the semen out of it. The only other way you can get DNA is by skin particles. There's no way you can get DNA from sweat. They'd like you to believe that? No, they can't. That's what the experts said. 4 ways of getting DNA. So, now the next day, after that, there's the autopsy. And at the autopsy, Detective Mikla's there, and the autopsy is done, and she, Dr. Mills, decides on that day that this is a homicide. On that day, when she decided this, she didn't know that the gun was 3 to 6 inches away. She didn't know that. She didn't know that Chase Fleischauer had a .278. She didn't know that. She didn't know that my client or Sommer did not have any gunshot residue on them. And she didn't know that he was sitting on a stool. She had not gone to the scene of this incident. And she said, well, the gun would have fallen right next to him if he had shot himself. She didn't know that this gun had a recoil, even though she went out and shot it herself. Or she didn't shoot it, went to the gunshot place where they do the testing, and it was 3 to 6 inches. So her opinion, and the judges instructed you, opinions are only as good as what you base them on. And she based it on what? What did she base the homicide on? The fact that Mikla was there and they had a guy in custody? What else? What did she base? She based it on his other bruises. Apparently, that's what she testified to. Dr. Retrial said the bruises weren't that serious, they're minor, they had nothing to do with the cause of death. But that's what she based, and she didn't ever change that. When she got the DNA GSR, the 6 feet, the 3 inches, the 6 inches, the .287, the fact he was sitting on a stool, none of that affected her decision. None of that affected McGee's decision. Is that outrageous or what? Is that believable? Wouldn't you at least pause and hesitate and review it again? And then we get to this is the most unreasonable evidence that is in this case. We get to the pre-existing fractures. First of all, the pre-existing fractures, coincidentally, are on the same side of the head as a gunshot wound. Well, let's forget the doctors for a change. Let's just have reason and common sense. If there's a couple fractures there and that bullet went in your head and it was a hollow point and never came out, would you think there would be a lot of fractures? Of course there would be. But she said, at least in her testimony, she said that these 2 fractures, temporal and lineal fractures, happened beforehand. We go get a medical examiner who lost his job in 2003. My gosh, that's terrible. After that, he's had jobs with the government, West Virginia. He's their medical examiner. You judge his credibility. You judge what he knows. You've seen his CV, what he's done in his life. And he looked at this. First of all, he said it was an accidental self-inflicted gunshot wound. But secondly, he said that these pre-existing injuries aren't true. And he explained it to you. But that's the doctors. Think about it for a minute. Why would there be pre-existing injuries? If he was hit hard on the head for a fracture, where's the weapon? Is there anything that these officers, the state, found with hair on it, with blood on it, with anything like a weapon that hit him on the head? And if he hit the ground with his head at some point in time in the head, where's that evidence? The fact is, the truth is, the opinion that is the most reliable is Dr. Arden. And why do I say that? Because it also jives with your own common sense and life experiences. When a bullet goes in your head like that, it's going to fracture all over. And no expert can ever say that, well, these are pre-existing fractures. And Dr. Arden established that for you. I'm almost done. Promise. Corey Burton testified, told you he's a friend. He got concerned, spent hours constructing a robot, like he calls it something else. You obviously wouldn't have somebody shoot a gun like that and test the recoil. You couldn't. And this human hand thing, the point of that testing was to show that when the gun recoiled, it ejected the shell and it also put a shell in. And as the expert from the state said, that depends on how tight you grip the pistol. And Arden says, well, it could have had his thumb on it or his finger. And let's back up about the injuries, which is a very interesting injury. It's the finger, the right trigger. It's called the trigger finger. Dr. Mills said that. And that injury, I said, well, hypothetically, could it have, that injury, could that have been caused by the gun flying out of his hand? Yes. The state says, well, wait a minute. When he shot himself, he's dead. There's no way that could be a bruise. She says, oh, yes, there could be. The blood pumps for 2 or 3 moments, she said. So there's more circumstantial evidence, not just the GSR and the DNA. You've got a bruise on his trigger finger when the gun flew off. What more do you need to have the reasonable explanation of this case that he did not, it's not a homicide where my client shot him. It's just, they just don't have any evidence, except the state pounding and pounding and pounding about he beat his son that day. If he was beating his son and he took his gun and shot him, what the heck is he doing sitting on a stool? Think about that. There wasn't any beating going on then. He was sitting on a stool. So it's just make up evidence. We don't have a case, and that's what they're doing. And when you go back there and you look at all this evidence, you remember what the evidence is and not what the state says or what I say, because we don't have evidence. And I could go through a litany of statements he made, I'm not going to do it, that just aren't true. So we got Dr. Trito. He saw the body at the time at the medical examiner's office. He says that the injuries were not that serious and that you'd expect injuries like this if 2 people drunk were wrestling on a hard floor or fighting or aggressive conduct. So what? The fact is he was shot. Self-inflicted shot was the cause of death. It wasn't the fracture of the head, which didn't exist. It wasn't the bruises on his lip. It wasn't the petechiae, which there was no strangulation. She said that. He tries to get in. She had a scratch on his neck. Yes. And there's DNA on the shirt of my client, of Chase. Yes, they were wrestling. And maybe it got carried away for a while. They were drunk. That doesn't make my client a murderer of his only son, ladies and gentlemen. So then we have, go back to Burton for a minute. His testing was not to recreate a scene of a car accident or anything like that. What his testing was to do was to find out if a recoil of that gun, loosely held by somebody who accidentally shot it would kick back up to the 10 feet 9 inches, which to this, we, just like Stalky says, we really don't, I don't know if that's the proper distance because it was picked up before, the gun was picked up before it was measured. So you might remember this, one of the gun was heavier, it had an extra bullet in it, but the gun flew back 9 feet, 8 feet, and ejected shells, and you saw it. He testified, you know, he pulled the string, and you saw the video where the piece of plastic comes out. He didn't have anything connected to that pistol. Is he the type of guy, you saw his character, would he be the type of guy to dummy up a test like that? No. An honest person who sees somebody that he doesn't believe should be in trouble, his own friend. Well, I'm done. I want to thank all of you for listening to me and watching this case and seeing all the evidence and paying attention. You're all very good jurors. I thank you on behalf of my client and Amanda Montgomery, my associate, and the family. Just remember that instruction. And that's what I'm going to leave you with. If you can reconcile, and you'll have these back there, but my goodness, this is so important. They know it's important because they cannot rule out accident. If you can reconcile the evidence upon any reasonable explanation, hypotheses, consistent with Kayle Fleischauer's innocence, you should do so and return a verdict of not guilty. That's what the law is. They have to prove it beyond a reasonable doubt, and my client's presumed innocent. On behalf of all those folks and myself, I thank you for your attention and do the right thing.
Thank you, Mr. Gray.